Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about hearsay. But don't forget to click like on this video if you're enjoying it, and if you like all these videos, click subscribe with a little bell next to it to be notified of future videos. So, the question, what is hearsay? And the answer to that, first, I am not going to do a law school class on what is hearsay. This is a very complicated subject in general with a lot of hearsay exceptions, and I'm not going to be going into all those, especially not in this video. Maybe in a future video. Put your question in the comments below, and we might get to it in a future video because there are a lot of hearsay exceptions. But when it comes to hearsay, the textbook answer is hearsay is an out-of-court statement used to prove the truth of the matter asserted. So in other words, if I say the sky was blue and we're trying to prove that the sky was blue, that would be a hearsay statement if I didn't know that from my own personal experience, not that I heard it from somebody else. The better way to think about it is you're testifying about something that somebody else told you. So, perfect example, if I'm testifying that my best friend's favorite color is blue, and I only know that because he told me, he said, "Hey Mark, my favorite color is blue," that would be a hearsay statement. Now, hearsay is not a problem when you're in certain kinds of hearings. In other words, if it's a preliminary hearing, a motions hearing, or a probation revocation hearing, hearsay is perfectly acceptable. Now, like I said in the intro, there are a lot of exceptions to the hearsay rule because generally hearsay is not admissible in a trial. However, a lot of exceptions. Just to mention a couple, excited utterances, statements for medical diagnosis, and so forth. And there are some document exceptions as well. But if you're testifying to something that somebody told you, then that's hearsay, and it should be challenged and probably kept out of evidence. So, hearsay. I get this question a lot, as in, when a police officer writes something or somebody sees something and they're writing a statement, and my client says, "But isn't that hearsay?" And I say, well, technically, yes. In the scope of the police report or in the statement that they made, that is hearsay. However, when they get up on the witness stand and testify to it, it's not hearsay. And again, they're testifying to what they saw, not that they made a prior statement. And like I said, this can be kind of a circular definition, because this can get confusing at times to some people, but at the same time, it's relatively straightforward when you look at it in terms of you get up on the witness stand and testify. The light was red when the car went through it. That would not be a hearsay statement. But if you were to try to testify that I told the police officer that the light was red, that would be hearsay. And again, that's what I like to explain to my clients when we're going to trial. That's a nuanced argument to a non-lawyer. But hearsay is when you make an out-of-court statement, or you're testifying to an out-of-court statement, which is used to prove what you're trying to say. So that's the question and answer for today. If you have any questions, and you should have questions on this one, they're easy enough to put the questions in the comments below, email it to me, or tag me on Twitter. And as always, you have a right to remain silent if the police officer asks you questions about where you've been, what you have, what you know. You always have a right to say, "I don't want to talk to you," and if they persist, "I want a lawyer."